desirable to define the limits of judicial discretion, but that proved to be impossible. It could not be determined in advance by abstract reasoning. Hence, as each litigation arose, the judges could follow no rule but the rule of common sense, and the police power, translated into plain English, presently came to signify whatever, at the moment, the judges happened to think reasonable. Consequently, they began guessing at the drift of public opinion as it percolated to them through the medium of their education and prejudices. Sometimes they guessed right and sometimes wrong, and when they guessed wrong they were cast aside, as appeared dramatically enough in the temperance agitation. Up to about the middle of the last century the lawfulness of the liquor business had been unquestioned in the United States, and money had been invested as freely in it as in any other legitimate enterprise, but as the temperance agitation swept over the country, in obedience to the impulsion given by science to the study of hygiene, dealing in liquor came to be condemned as a crime. Presently legislatures began to pass statutes to confiscate more or less completely this kind of property, and sufferers brought their cases before the courts to have the constitutionality of the acts tested, under the provisions which existed in all state constitutions, forbidding the taking by the public of private property without compensation or without due process of law. Such a provision existed in the Constitution of the State of New York, adopted in 1846, and it was to invoke the protection of this clause that one Winhammer, who had been indicted in 1855, carried his case to the Court of Appeals in the year 1856. In that cause Mr. Justice Comstock, who was one of the ablest jurists New York ever produced, gave an opinion which is a model of judicial reasoning. He showed conclusively the absurdity of constitutional restrictions, if due process of law may be held to mean the enactment of the very statute drawn to work confiscation. This decision, which represented the profoundest convictions of men of the caliber of Comstock and Denio, deserves to rank with Marshall's effort in the Dartmouth College case. In both instances the tribunal exerted itself to carry out Hamilton's principle of judicial duty by exercising its judgment and not its will. In other words, the judges propounded a general rule and then simply determined whether the set of facts presented to them fell within that rule. They resolutely declined to legislate by entering upon a consideration of the soundness or reasonableness of the policy which underlay the action of the legislature. In the one case as in the other the effort was unavailing, as Jefferson prophesied that it would be. I have told Marshall's overthrow in the Charles River Bridge case, and in 1887, after controversies of this category had begun to come before the Supreme Court of the United States under the 14th Amendment, Mr. Justice Harlan swept Mr. Justice Comstock aside by quietly ignoring an argument which was unanswerable. The same series of phenomena have appeared in regard to laws confiscating property invested in lotteries, when opinion turned against lotteries, or in occupations supposed to be unsanitary, as in the celebrated case of the taxing out of existence of the rendering establishment which had been erected as a public benefit to relieve the city of Chicago of its offal. In fine, whenever pressure has reached a given intensity, on one pretext or another, courts have enforced or dispensed with constitutional limitations with quite as much facility as have legislatures, and for the same reasons. The only difference has been that the pressure which has operated most directly upon courts has not always been the pressure which has swayed legislatures, though sometimes both influences have combined. For example, during the Civil War the courts sanctioned everything the popular majority demanded under the pretext of the war power, as in peace they have sanctioned confiscations for certain popular purposes, under the name of the police power. But then, courts have always been sensitive to financial influences, and if they have been flexible in permitting popular confiscation when the path of least resistance has lain that way, they have gone quite as far in the reverse direction when the amount of capital threatened has been large enough to be with them a countervailing force. As the federal Constitution originally contained no restriction upon the states touching the confiscation of the property of their own citizens, provided contracts were not impaired, it was only in 1868, by the passage of the 14th Amendment, that the Supreme Court of the United States acquired the possibility of becoming the censor of state legislation in such matters. Nor did the Supreme Court accept this burden very willingly or in haste. For a number of years it labored to confine its function to defining the limits of the police power, guarding itself from the responsibility of passing upon the reasonableness with which that power was used. It was only by somewhat slow degrees, as the value of the threatened property grew to be vast, that the court was deflected from this conservative course into effective legislation. The first prayers for relief came from the Southern states, who were still groaning under Reconstruction governments, but as the Southern whites were then rather poor, their complaints were neglected. The first very famous cause of this category is known as the slaughterhouse cases. In 1869 the carpet-bag government of Louisiana conceived the plan of confiscating most of the property of the butchers who slaughtered for New Orleans, within a district about as large as the state of Rhode Island. The 14th Amendment forbade states to deprive any person of life, liberty, or property without due process of law, and the butchers of New Orleans prayed for protection, alleging that the manner in which their property had been taken was utterly lawless. But the Supreme Court declined to interfere, explaining that the 14th Amendment had been contrived to protect the emancipated slaves, and not to make the federal judiciary a perpetual censor upon all legislation of the states on the civil rights of their own citizens, with authority to nullify such as it did not approve. Although, even at that relatively early day, this conservatism met with a strong opposition within the court itself, the pressure of vested wealth did not gather enough momentum to overcome the inertia of the bench for nearly another generation. It was the concentration of capital in monopoly and the consequent effort by the public to regulate monopoly prices which created the stress which changed the legal equilibrium. The modern American monopoly seems first to have generated at that moment of friction, which habitually finds vent in a great litigation, about the year 1870. But only some years later did the states enter upon a determined policy of regulating monopoly prices by law, with the establishment by the Illinois legislature of a tariff for the Chicago elevators. The elevator companies resisted, on the ground that regulation of prices in private business was equivalent to confiscation, and so, in 1876, the Supreme Court was dragged into this fiercest of controversies, thereby becoming subject to a stress to which no judiciary can safely be exposed. Obviously two questions were presented for adjudication. The first, which by courtesy might be termed legal, was whether the fixing of prices by statute was a prerogative which a state legislature might constitutionally exercise at all. The second, which was purely political, was whether, admitting that in the abstract such a power could be exercised by the state, Illinois had, in this particular case, behaved reasonably. The Supreme Court made a conscientious effort to adhere to the theory of Hamilton that it should, in emergencies like this, use its judgment only, and not its will, that it should lay down a rule, not vote on the wisdom of a policy. So the judges decided that, from time immemorial, the fixing of prices in certain trades and occupations had been a legislative function, which they supposed might be classified as a branch of the police power, but they declared that with this expression of opinion their jurisdiction ended. When it came to asking them to criticize the propriety of legislation, it was, in substance, proposing that they should substitute their will for the will of the representatives of the people, which was impossible. I will remember the stir made by the case of Munn versus Illinois. Both in and out of the legal profession, those in harmony with the great vested interests complained that the court had shirked its duty. But these complaints soon ceased, for a movement was in progress which swept, for the moment, all before it. The great aggregations of capital which had